Okay, folks seem interested in hearing more about the Sandoval hearing that was conducted on Friday and Judge Merchan's upcoming ruling on it and how it will impact Trump's ability to testify in his trial. I'm Eliza Orlins, career public defender here in Manhattan for the last 14 years. So by way of background, under Sandoval, the defense is entitled to a pretrial ruling as to what prior bad acts, either criminal convictions or often uncharged crimes, can be utilized to impeach the credibility of the defendant if that person is to take the stand and testify in their own defense. This evidence would be being used simply to impeach the defendant's credibility and not as substantive evidence to prove that the defendant committed this crime or that they had the propensity to commit crimes. This is simply on the issue of the defendant's credibility. Now, the reason why you need to obtain a pretrial ruling is because this could impact the defense's strategy. Depending on the Sandoval ruling, for example, in some of my cases, it has made it so that my client either couldn't or truly shouldn't testify, because we realized if my client got on the stand, the things that they would be subjected to cross-examination on would make it so that their testimony would have little weight because their credibility would be so deeply impacted by this pretrial ruling. So even though this was argued on Friday, the judge reserved his ruling, but I presume he will rule before opening statements tomorrow. And now let's get into the specifics. Okay, the first thing that the prosecution is trying to introduce at trial to impeach the credibility of Donald Trump if he gets on the stand is People by James versus Trump. And it's two parts. The first is defendant repeatedly and persistently falsified business records, conspired to falsify business records, issued false financial statements, conspired to issue false financial statements, and conspired to commit insurance fraud by fraudulently misstating the value of his assets for economic benefit, including the Trump Tower triplex, by overstating its square footage by nearly 3 times, the Seven Springs estate by valuing the property at up to 29 times appraised values, 40 Wall Street by valuing the property at nearly 200 million more than its appraised value, and a golf course in Aberdeen, Scotland by valuing the property as if Trump organization could build 2,500 year-round private residences when in fact they only had permission to build 500. Court ordered defendant to pay $354,868,768 in penalties and enjoined the defendant from serving as an officer or director of any New York corporation for 3 years. And then part 2 of this is defendant testified untruthfully under oath when he claimed that his public comments about a judge's law clerk were instead about a witness. Court held, as the trier of fact, I find Trump's testimony rings hollow and untrue. And actually, there are 3 more parts from this case. Defendant intentionally violated court order by making public attacks on a judge's law clerk despite 2 prior court orders not to do so. Court fined defendant $10,000. Defendant violated court order by failing to remove untrue, disparaging, and personally identifying post about the court's principal law clerk from the website donaldjtrump.com. Court fined defendant $5,000. Defendant committed repeated and persistent fraud in the transaction of business by fraudulently misstating the value of his assets, including the Trump Tower triplex, the Seven Springs estate, 40 Wall Street, and a golf course in Aberdeen, Scotland, in statements of financial condition in order to mislead financial counterparties and obtain economic benefits. Next case is Carroll versus Trump. 2 parts. Defamation damages determination. Jury awarded E. Jean Carroll $83,300,000 in compensatory and punitive damages for defamatory statements defendant made about her on June 21st and June 22nd, 2019. And defendant defamed E. Jean Carroll in public statements on June 21st and June 22nd, 2019 by making false statements with actual malice. Then the other Carroll versus Trump, the sexual abuse determination. Defendant sexually abused E. Jean Carroll. Jury awarded the plaintiff $2,020,000 in compensatory and punitive damages on her sexual abuse claim. And defendant defamed E. Jean Carroll in public statement made on October 12th, 2022 on Truth Social by making false statement with actual malice. Jury awarded the plaintiff $2.98 million in compensatory and punitive damages on her defamation claim. Moving right along to Trump v. Clinton, determination. Court sanctioned defendant and ordered him to pay $937,989 in fees for filing a frivolous bad faith lawsuit. Court held, here we are confronted with a lawsuit that should never have been filed, which was completely frivolous, both factually and legally, and which was brought in bad faith for an improper purpose. Mr. Trump is a prolific and sophisticated litigant who is repeatedly using the courts to seek revenge on political adversaries. He is the mastermind of strategic abuse of the judicial process, and he cannot be seen as a litigant blindly following the advice of his lawyer. He knew full well the impact of his actions. Next up, People versus the Trump Corporation. They want the determination in Trump Corporation and Trump Payroll Corp convicted of 17 felony counts of scheme to defraud, conspiracy, criminal tax fraud, and falsifying business records in connection with a scheme to pay unreported non-cash compensation to top executives, including Alan Weisselberg. And finally on this page, People by James v. Trump, determination and underlying facts. Defendant illegally allowed his 2016 presidential campaign to orchestrate a fundraiser for the Donald J. Trump Foundation, direct distribution of the funds, and use the fundraiser and distribution of the funds to further defendant's political campaign. Court ordered defendant to pay $2 million for breach of fiduciary duty and waste. And also they're trying to get in the stipulation, which is down here. Defendant stipulated to the dissolution of the Donald J. Trump Foundation to resolve claims by the New York Attorney General of breach of fiduciary duty and waste, failure to properly administer charitable assets, improper political activity, unlawful coordination with the Trump political campaign, and repeated and willful self-dealing transactions. And apparently this motion doesn't even include the other disclosed misconduct and alleged uncharged criminal acts that they intend to use at trial as substantive proof of some material issues. And they are giving notice here that if they are not entitled to use those things as substantive proof, they also intend to use the things that were identified in those motions to impeach the credibility of the defendant. Whew, we got through it all. Now, just to clarify what Sandoval hearings are typically like, at the Sandoval hearing, the judge will weigh the probative value of the bad act for the purposes of evaluating the defendant's credibility against the risk of unfair prejudice, as measured by the tendency to influence the jury on issues other than credibility and its potential to discourage the defendant from testifying and thereby deprive the fact finder of valuable evidence. So basically that's saying that the incentive of the judge is to weigh these things and make sure that he's not making a ruling that makes it impossible for the defendant, if they want to testify in their own defense, to be able to do so, but also to weigh the probative value, if something is truly probative on someone's credibility, to allow that in. If that person gets on the stand and there they are swearing to tell the truth, the whole truth, nothing but the truth, and if there's something that truly weighs on that person's credibility, that the judge feels the need to let them in. Strangely, in most of my cases, typically these rulings would be made prior to jury selection, because sometimes if your client is going to testify and certain bad acts are going to come in, you want to ask the jury about it in jury selection and see how they're going to react to those things. So I'm a little bit surprised that they haven't made this ruling yet, but I'm sure it's been discussed at length. Let me know if you want more on this. There are other things that I would argue if I were the defense, different ways in which I think, it would be pretty unfair for the judge to allow certain of these things in, because I think that a lot of it really would be being used as propensity evidence, as evidence to show that the defendant had the propensity to commit these crimes, and don't really go to his credibility, while some others may go more to credibility. But anyhow, sorry this is getting so long, but I hope that you find it really interesting, and make sure you're following for more, like my content and share it. And I really appreciate you being here, and feel free to leave more questions in the comments. Thanks.